Hello guys, welcome back to channel Rahul Brand Study. In this video, we will cover a case, namely Town Area Committee versus Prabhu Dayal, All India Report 1975. So before move ahead, please subscribe this channel and press the bell icon to get notification on time. You can also subscribe my Telegram channel, namely Rahul Brand Study. So, judgment given by Justice Hari Swarup. Plaintiff's case was that he had made construction of 16 shops on the old foundations of the building known as the Garhi, and the defendant town area committee acting through its chairman and vice chairman, who are defendants 2 and 3, illegally demolished this construction. By this demolition, plaintiff suffered a loss of 1,000 according to him. The notice under section 186 of the Uttar Pradesh Municipal Act was bad as it gave to the plaintiff only 2 hours time to demolish and construction and not reasonable time as completed in section 302 of the Act. It was also asserted that the demolition after this notice was bad as the notice was served at the time when the plaintiff was out of station. The action was said to be mala fide, it is bad faith. Bona fide, it is good faith. So, second, the plea of the defendants was that construction had been made by the plaintiff without giving the notice of intention to erect the building under section 178 and without obtaining the necessary sanction under section 180 of the Act. It was denied that the action was malified, and it was asserted that the notice to demolish the construction had been given earlier on 80th December, requiring the stoppage of further construction and removal of constructions already made, and when it was not complied with, an order had been passed by the district magistrate directing the town area committee to take action under section 186. Thereafter, another notice was given on December 21, which was not complied with, and thereafter another notice was given December 21, which also was not complied with, and only then the building was demolished in accordance with law. On these grounds, it was alleged that the plaintiff was not entitled to claim any damages. Coming to the merits of the case, it appears that the lower appellate court has completely misdirected itself. The claim was on the basis of damages caused to the plaintiff by an act of the defendants. The plaintiff can get compensation only if he proves to have suffered injury because of illegal act of the defendant and not otherwise. Malice does not enter the scene at all. A legal act, though motivated by malice, will not make the actor liable to pay damages. This proposition finds support from the Saman's observation. So, to a landlord who serves a valid notice to Kit cannot be held liable in tort because his motive was the vindicative, vindicative, vindictive one of punishing the tenants for having given evidence against him in other proceedings. Salmon, a thinker on law of torts, and Infield talk about the law of tort, and Salmon talk about the law of torts. So, guys, you can brief on the two distinction between law of tort and law of torts. Law of tort is a broader term, while law of torts is narrower term. Simons refers the law of torts, and Winfield refers the law of tort. So, 15th edition, page number 18. Okay, merely because some officer has malice against a citizen who has committed a wrong will not render the action of the authority invalid if it is otherwise in accordance with law. Mere malice cannot disentitle a person from taking recourse to law for getting the wrong undone. It is therefore not necessary to investigate whether the action was motivated by malice or not. Seventh point, before the plaintiff can get any damages, that is remedy, he must prove that he had suffered an injury. Law does not take into account all the harms suffered by a person which caused to legal injury. Damage should done is called damnum sine injuria, that is damage without injury. Damage without legal injury. Such a damage does not give the sufferer any right to get compensation. There is another term, namely injuria sine damnum, that is injury without damage. The term injuria is to understood is in its original and proper sense of wrong. In just contrary to law, Salmon on Law of Torts, page number 17. In this present case, there is no doubt that the plaintiff was himself guilty of committing the wrong. As found by the trial court, the plaintiff had not given any notice under section 178 of Uttar Pradesh Municipalities Act and had not obtained the sanction completed by section 180. According to the finding of the trial court, the building abuts a public street and prior notice and section were necessary. These findings have not been reversed by the appellate court. Section 185 of the Act says, whoever being continues or completes the erection or re-erection of or any material alteration in a building or a part of building or construction or enlargement of a well without giving the notice required by section 178 or in contravention of the provision of section 180 subsection 5 or of any order of the boards refusing section or any written directions made by the board under section 180 or any by law shall be liable upon conviction to a fine which may extend to 1000 rupees, but which is in absence of special and adequate reasons to the contrary to be mentioned in the judgment of the court shall not be less than 250 rupees. Section 186 of the Act gives the board a power to demolish a construction, the making of which amount to an offence under section 185 of the Act. 8th point, according to the learned counsel for the plaintiff, the demolition was not done in accordance with the law, as the notice did not give reasonable time, and hence the municipal board will be liable to pay damages. Notice, though of an earlier date, the served on the 18th and it required demolition before 18th. Of course, such a notice could not be complied with in its terms, but that would not authorize the plaintiff to maintain the construction illegally made. The plaintiff did not appear before the authority to show cause why the building should not be abolished again. After 3 days, another notice was given and the building was thereafter demolished. There was no objection made that the 2 hours time given in the notice of 21st was insufficient. Had the plaintiff made a complaint that he had suffered a loss because the demolition was done the same day and would not have suffered loss, it is greater if greater time had been granted for the demolition the illegal construction. That would have been a different matter. The case of the plaintiff, however, was that he had a right to maintain the building and the action of board was bad because it was malified. In this failure, in this failure, the time factor ceases to be any importance. The notice can, in these circumstances, be said to be such as to make the consequential action illegal. There is also no merit in the contention of the learned counsel that the plaintiff had suffered injury by the act of the demolition of the building because he had a fundamental right to hold and enjoy the property even though it was constructed without the prior sanction from the municipality authority. There is no right to enjoy property not illegally obtained or constructed. A person has been given by law a right to construct a building, but that right is restricted by various enactments, one of which is UP Municipalities Act. If a person constructs a building illegally, the demolition of such building by the municipality's authority would not amount to causing injury, that is legal injury, to the owner of property. No person has the right to enjoy the fruits of an act which is an offense under law. Number 10. As the plaintiff has failed to prove that he had suffered injury in the legal sense, he is not entitled to get any compensation. The degree of the court below cannot, even though the plaintiff may have suffered damages, be sustained. In the result, the appeal is allowed. The degree of the lower appellate court is set aside and that of the trial court restored. This is the case about the illegal construction, and plaintiff and the defendant argued on the subject, and Justice Sapru Swarup Hari Swarup read the judgment. So guys, that's it for now. I will cover next in next video another case, namely I will just follow the case material provided by or given by Dayal University for the loss LLB student first semester. So I just continue the series of the case. So in next video I will cover the P. Sitaramaiya versus G. Mahalakshmamu all 1958 का केस है. We'll just cover this case in that next video. So thank you so much for watching, guys. So guys, when I just read the case, you also open your PDF or a physical copy of the law of tort case mates. So just you will try to understand facts, judgment, and the mechanism of tort applied in the case. So guys, you will just get some benefit after reading the mates, case mates. So I hope uh, it will be helpful for us. So guys, that's it for now. Thank you so much for watching this video. Bye bye, take care.